Friends, good morning. I'm B.S. Tyati from Global College of Law. At the outset, I congratulate every human being today on Buddha Purnima. And now I shall come to the subject matter. So there has been demand from students of BA LLB for one practical subject guidelines online. Accordingly, as in past or you say last semester, we had come out one video class on moot court exercise, and accordingly today I shall be giving certain points and highlights on drafting, pleading and conveyancing, DPC. These are the three areas. One is drafting of what? Pleadings and conveyancing. See, any law student who knows drafting is an asset for the legal world. In my opinion, very important area which every student is supposed to do with great interest is to learn how to draft pleadings and conveyancing. This is one very important practical subject for the student of LLB 3 years as well as for the students of BA LLB. This is, I suppose, 8th semester. Yeah. So here, what are the important points to be borne in mind by every student and how to attempt the practical subject for which there is exclusive practical paper of 100 marks on drafting, pleading and conveyancing. Again I repeat, drafting of pleadings and conveyancing. Drafting, I hope you well understand what drafting is, means how to place the mind of your client in the form of a plaint or to the reply of client as WS, or drafting of various different type of the applications like memorandum of appeal, like PIL, like appeal, like say plaint, like WS, along with affidavits and affidavit. So the drafting of these all papers or documents required to contest one case or suit in the court is of very paramount importance. When we talk of drafting, so one student is supposed to know the general principles and relevant substantive rules to be followed while drafting. When we talk of pleadings, what do you mean by pleadings? There are two types of pleadings, one is civil and one is criminal. When we talk of the civil, of course we have to go for the plaint or WS, interlocutory application, original petition, affidavit, execution petition, memorandum of appeal, and revision of petition under article of revision or petition under article 226 or article 32 of the Constitution of India. And when we talk of the criminal pleadings, it is a complaint, criminal miscellaneous petition, bail application, memorandum of appeal and revision. So these are the pleadings for which drafting is to be done. Accordingly, the drafting of conveyancing, When we talk of conveyancing, I hope students have been taught in the class. Conveyancing means movement of rights of one person to another person on particular fixed assets in the form of conveyance, sale deed, mortgage deed, lease deed, gift deed, promissory note, power of attorney, will, trust deed. So these are called conveyancing. Drafting of writ petitions and PIL petitions. So this is both the areas where one student of legal study is supposed to have perfect idea to survive with respect while practicing as advocate. These all the things are taught as theory in the classes, but since the subject is very important, so the University and Bar Council of India have thought fit that there should be one practical examination. So when we talk of practical examination, so every student is supposed to write 15 pleadings and 15 conveyance deeds, and each item contains 3 marks. So when we talk of 15 into 3, 45, and second lot 15 into 3 again 45, total comes 90, and then 10 for biography. So for 90 marks there is a complete file to be prepared by the student, whereas 15 pleadings are to be properly drawn and 15 conveyance deeds are to be drawn properly. You have to know what to be written in what part. See, there are certain, I told you, general principles of drafting and relevant substantive laws are there, which have been taught very well in the classes to the students, and also whenever the students have demanded, teachers have also given their full idea. Various sources of study materials have been provided also. And today we have come forward for this YouTube channel cassette of college, Global College of Law, where I'm giving you this class. When we talk of drafting, you should know what type of when we draft a plaint. Plaint contains how many parts? Plaint of any civil matter contains 4 parts. One is operative part, which contains the name of the court, suit number, name of parties, that is called upper part. Then second part comes, in which one has to go for stamping, valuation, and jurisdiction of the court. Subject matter, and third part is operative part, in which one has to go for the facts, material facts of the matter. When we talk of the facts, I hope students know, when we talk of the material facts, based on which the cause of action and the issues are framed. Cause of action is very important. Without cause of action, your suit cannot be established and issues cannot be framed. And the last part is called the verification, in which the plaintiff has to verify the facts and to submit through the counsel. Counsel, any application in the court of law, any court of law cannot be produced by any party directly, but through the counsel. And application of plaint has to be along with the affidavit. Affidavit is the affirmation on oath of the facts, material facts given in the plaintiff application, and this affidavit is to be done before the oath commissioner, because all the internal matters of the courts are to be taken oath with the oath commissioner. However, any issues requiring outside the court are to be done by the notary, public notary. So here this subject is not important what I have narrated. So here, as a narrator, because I am talking about the lawyer advocate, whom we can call also narrator, has to take care of all the issues, and then application is to be prepared. This is called the preparation drafting. And accordingly the WS, when we talk, WS is point to point reply, acceptance or negation of the facts in the application. Again same verification, and additional pleas also can be given in case something is left and not covered under the reply. On merits, then again this WS is to be on the affidavit to be submitted in the court. So if required, there will be rejoinder by either of the parties, like plaintiff or defendant. So this is one drafting of civil matter, and accordingly in the criminal, we have to bear in mind then while drafting facts to be to the point without narrating stories, because court doesn't need, court needs only those facts which are relevant and based on which a judgment can be drawn. See, the areas which are accepted by the defendant are rounded up and there is no argument on that, and only the points of variance on which the issues are framed are to be contested. If variance is not there and if there is no cause of action, of course the suit doesn't have validity. Accordingly, what documents we have told are supposed to be drafted, and the drafting is very important as we told. Affidavit, when we talk, one has to bear in mind that the first line of the affidavit is affirmation on oath, then verification before the oath commissioner or notary. Memorandum of appeal, again the same when we go for filing an appeal. Based on the judgment impute, which is disputed judgment on which you have to go for appeal, you have to bear in mind that only legal additional point can be raised in appeal, otherwise no additional fact or material fact can be added until unless it is permitted by the court, which is very rarest of the rare matter. However, any legal point, if it is left, can be well placed before the court appellate authority. So these are the things when we talk of the petition. Revision can be done, revision of the judgment of the appeal can be had. Review can be had by the very court which has passed the order. When we talk of revision, of course, this is the higher court. Suppose any civil matter under limitation has gone to the court for disposal and the matter is disposed of, so the second party, aggrieved party, has to go for the revision to the higher court. So revision application has to be framed accordingly. Suppose the points which are very pertinent and have been not taken care by the court while passing the order, a revision court means the higher court has jurisdiction to hear such applications. Accordingly, in the criminal matters, application, criminal application, civil appeal, criminal application, memorandum of appeal and revision are to be framed by the advocate. Now when we talk of the conveyance deed, sale deed, What is sale deed? Sale deed means sale of any immovable property under which transfer of rights from one person to another, and there should be proper consideration. Without consideration, sale doesn't take place. Accordingly, in mortgage deed only the title is transferred, whereas the possession of the property is not transferred. Under lease deed only the using rights are there, no sale deed, so sale rights, only lease is the specific purpose. And in gift deed again, without consideration, this is just like transfer deed of rights of assets. Promissory note again, it is a DPN which is on demand, payable on demand. So it can be also endorsed. Suppose it is A to B and B can endorse to C. So C can claim from A and C can again endorse to D, D can claim from A. Likewise, so this is called DPN. Power of attorney well known, it is of two types, one is general power, one is specific power, under which there is no power to sell. Only it is for the management of the assets, like leasing out, like many things, but not at all sale, until unless it is specifically mentioned. And sale in case is done, then the sale proceeds have to come in the name of the owner, not in the name of the power of attorney holder. See, suppose any house, one has given authority to a particular person as power of attorney holder to sell the house, so he can arrange the buyer, but when it is sold based on the power of attorney, the proceeds of the consideration will be in the name of the owner only. Will, in last session also we have placed one will. Will is a very legal document under which one can, by free desire, arrange for the disposal of his assets after his death. Trust deed again, it is as per Trust Act 1882. Trust deed is to be prepared. Drafting of writ petitions and PIL applications, it is also in the same series, so one should know. And when we go for preparing the practical file, after learning, reading, understanding these all both areas, drafting of pleadings and drafting of conveyancing, we have to go to file preparation. For practical file of Global College of Law, as we have been doing in the recent past, it has to be on the legal size page, one side written with margin on top and bottom, right and left, proper margin. Legal size page and margin, what is the difference? How much margin is required? Legal size page you can place from the downside, A4 paper from downside leaving 1 inch. So whatever area is left on all 4 sides is called margin. Only A4 equal to A4 is to be written on legal size page, and rest is to be left as margin. It's to be in the blue and black pen only. One side written, hand written. Indexing is to be required. When we talk of pleadings, drafting of pleadings, first of all we have to write certain principles, general principles of drafting, and also the substantive law based on which we go for the drafting. Substantive rules are there as we told and also taught in the classes. So that is to be done. See, first page of the file to contain about the college logo, college name, college address, university name, university address, affiliated to university. Then subject name, practical subject like drafting of pleadings and conveyancing. accordingly name of student and name of the subject teacher, first page. And second page should be a letter of thanks to the subject teacher for his support, guidance. Third page should be the indexing. As we told, uh, index should be proper, index should be there. Or top college name, then index. So serial number 1, 2, 3, 4, 5, and right hand side page number from which page to which page. Serial number 1, what is there? Like general principles, like substantive rules, then drafting of pleadings. Which pleading? 15 pleadings are to be given. 50 civil or criminal, maybe both types. Specifically, you should know how to write. When we talk accordingly for conveyancing, 15, you should know what affidavit is, what trust deed is, what DPN is, everything one should know. In case one is perfect in writing and understanding these all the things, I suppose he will be a successful advocate after passing the degree. Global College has been emphasizing on the practice of writing, on English improvement, which is very important for pleadings. See, one has to write these all the things. Can write also in Hindi, but in case he is perfect in English, I suppose there is no match. So this way, file is to be prepared. Now exam, practical exam for the coming days for this current session. This is the even session, 8th semester is, I hope, in July 2020. It has got late due to the onslaught of the coronavirus, but now we are coming out of it, and university has also announced that from 1st of July things will start as usual. So through this my lecture, I have given proper guidance to the students, and I want that they should prepare very well. They should get their file checked immediately with the subject teacher. Any case, any doubt is there about any issue, as we told, injunction application, bailment application, whatever. So we can give the specific format also, and they should keep in mind how to write and what important areas to be borne in mind. For everything we have got draft letters, draft formats, and we are there at their disposal. Every time we call, we attend to all needs of the students, and I'm sure that a student will be benefited this thing. Last time we had come out with one moot court video. Today we are about pleading, say drafting, pleading, and conveyancing. And if required, we will go for another practical subjects also. And I'm sure that the students will be benefited, and with this YouTube channel of Global College of Law, which has got popularity amongst the students, not only of Global College of Law, otherwise as well. And I request, in case they like this cassette, they should subscribe. There is no charges. It has been of great use to the students, not only LLB, BLLB, but also people who are preparing for their judiciary exams, as well as for practicing in the courts. So thank you very much. Thank you very much. Thank you so much.